Welcome, everybody. My name is Olivia Cessna from the Center for Behavioral Health and Justice. I am a AOT coordinator at the CBHJ. Today, we will be talking about forms because as we have held these community of practice and we have been talking with y'all through different means of interviews and surveys, what we're doing, we're finding that with there's a lot of disconnect with the forms, just various barriers and things people are experiencing county to county. So with that being something that's reoccurring and coming up a lot as a theme, we thought that we would address that today. So what we're going to do is there are a couple of forms I've already identified that I think would be helpful for us to not necessarily like go over how to fill it out, but just kind of introduce the form and just see if there's any issues people are having with it, kind of state like what they are, when you use them, those kinds of things. But I want to stress that I want this to be less formal than our usual structure. We usually move forward with having a presentation and then kind of a formal Q&A, but I would like this to be more of a discussion. So as we are talking about these forms and as we're bringing them up, please raise your hand or just chime in like a question you may have or an experience you have with this particular form, maybe an experience that you've had with it, whether it is sufficient or not, whatever. I would like for this to be more discussion based than anything. But that being said, I am going to go ahead and launch a quick survey. Basically, kind of, if you guys could fill out that survey, it's asking what, sorry, it's not letting me do it now. It's asking what forms you've had trouble with or that you'd like to address in this space. So I'm going to go ahead and figure out how to launch that now. I think I accidentally made myself not the host anymore. So hold on. Okay. So silly. All right, here we go. So I'm going to go ahead and launch this poll. If you don't have trouble with any forms ever all the time, then no need to even fill it out. But if there's any form that you see that you would like to address in this space, or if there's trouble or anything like that, go ahead and just fill that out. There's a lot of forms, so I'm going to wait for like a minute or so to let y'all peruse those. Okay. So as the poll is still going, I'll leave it open for a little bit longer. I'll go ahead and start to share the first form that will kind of bring to the forefront here, which is the request to defer hearing on commitment, the PCM 235. And I'm going to go ahead. We have Kristina Morgan here. Yes, we have Kristina Morgan here to talk through these forms with us. So yeah, I'll go ahead and share my screen, and then I'll go ahead and kick it over to Kristina. There we go.
Good morning. Thank you, Olivia.
Of course.
Now, I do want to preface this by saying this form has been modified for Wayne County.
Oh.
That's okay. That's okay. It's a good way to show what we have changed in order to ensure that some of the information that we need to capture is here. So this change has been made so that each hospital filling out the deferment form actually has to specify what AOT services are necessary for that individual, so that it's all spelled out. All they have to do is check the boxes. I know some other counties may be doing something similar, but we thought that it was really a good thing to do, because oftentimes the court would receive requests to defer commitments with no outpatient treatment specified. So this makes it a little bit easier for those filling it out to say exactly what is needed for the individual that's being petitioned. So I'll start off by asking if anyone has any general questions about the deferral form, or anything that they want to add about the deferral form. Is it clear to everybody? Is it pretty, to me, it's pretty straightforward. It's probably the easiest form of them all. But if anybody has any questions, please, I'll be glad to answer them. Okay. I think we can move on to the next form, Olivia.
I'm
Okay.
sorry, I was trying to chat in the chat box, but it
Oh.
wasn't happening fast enough. These changes that you made for your county, have you submitted these requests to be like a statewide permanent change to this form?
Yes.
And if so, great. If not, how did you get to utilize changes only for your county?
So we have been working with Judge Matt to have this as a standard form as far as the AOT services being listed. In our county, of course, because it's not an actual scale form, once we made those modifications, then we can't mandate that this form is submitted. So
Hey,
if we—
Kristina, Judge Mack did make those changes. This is the new form.
Oh, it is the new form. I'm sorry, Jenny. Thank you.
You're welcome.
Thank you, Jenny. Thank you. These changes are made. But we do have a few forms within Wayne County that we've changed that we cannot mandate. So that's a good question, like they said in the chat. So what happens is, if you decide to make changes based on what's going on in your county, you can't mandate that that form be submitted to the court. So you can make those changes, and people can submit either that form or the actual scale form.
I'm just curious how it works for you in terms of hospitals, of course, all over the state, right? In terms of, how are you getting them to cooperate with you on forms that you've altered?
Well, we no longer hear out-of-county cases in Wayne County. So we don't have that experience. Our chief judge made that determination in 2023. So it was rolled out in a series of phases where we no longer hear out-county cases in Wayne County. So we only hear cases that are Wayne County residents. So we don't have that issue in Wayne County.
So that's what I mean, though, is if it's a Wayne County resident who happens to be hospitalized in Muskegon County, you're still hearing that case, correct?
Correct.
So how would you get this hospital locally here to cooperate with changes you've made to forms?
We send those forms. So we send those forms out in the packet. So we would send those forms in our petition packet.
Okay.
Yeah. Somebody said when submitting the PCM 235, I'm sorry, Sandy said when submitting the PCM 235, what are the steps to notify DWIN and the court? So are you referring to scheduling a deferral conference, or I'm not exactly sure what the question is here?
My apologies. I had a stroke. Bear with me.
No worries.
When we are requesting to defer the hearing, there are steps. We're aware of this. We just want to know both DWIN to be notified and the court, or just the court?
DWIN and the court. So DWIN should also be notified as well.
Thank you.
You're welcome.
This is great. Like I said, I had kind of, general questions and just wanting to know, kind of had it a little bit structured, but if you have any general questions, just take it and run with it. So that being said, is there any more questions about PCM 235 or can we move on?
Yeah, I just want to clarify before we move on. So the form that we're looking at here is a changed form. This is the changed version, and that is for the whole state of Michigan. Okay.
Correct. Thank you. Thank you, Jenny.
Wonderful.
Hi, Kristina. This is Sojourner. The only thing I want to add for the deferral, you will notice that it says CMH representative. Need to make sure whoever is attending from the CMH or the PIHP, their information is listed there prior to sending this document back to the court.
Thank you, Sojo. Yeah,
Olivia, you might want to scroll down.
Scroll down a little bit. Yeah, there we go. So at the deferral conference, the statute mandates that a representative of the CMH should be present. So in Wayne County, if the CMH provider is not able to attend, then someone from DWIN attends that deferral conference. Or if they're not assigned to an agency, then DWIN would attend. That information needs to be listed where it says deferral meeting attendees. The person who actually attended that deferral conference needs to sign there. The representative from the hospital, whoever the patient requested to attend can sign. So a guardian or other family support, if they were present at the deferral conference, their information needs to be listed. And then of course, under number 4, that has not changed. The actual respondent or patient, and then their legal counsel should be signing that form as well. And their attorney should also be present at the deferral conference.
Wonderful. All right. So we'll go ahead and move on to PCM 216, order and report on alternative mental health treatment.
Thank you. Are there any questions on this form?
I have a question. It's not really a question. It's more an observation. We are only included in one hospital that we use in these hearings. We're never notified. How do you?
Of the deferral conference?
Never. Just one hospital, one local hospital. And we, North Country, we admit all over the state, but we're not notified.
So you should definitely be notified. What happens is once the petition has been received and processed by the probate court, then the statute mandates that the deferral conference must be held within 72 hours of that happening. So the hospital, between the hospital and the attorney, they should be communicating to determine a time as to when that deferral conference shall be had. And then they should be notifying either the provider, so that would be you, or the any other PIHP, to inform of the deferral conference. If those notifications are not being made, I would probably start with the probate court to see if they can assist with that. I know we had some trouble initially in Wayne County where deferral conferences weren't being had at all. And our judge was able to send out a letter and a communication to hospitals and attorneys, letting them know what the statute was and the requirement for deferral conferences.
Thank you.
You're welcome. And then I see in the chat from Jennifer that you get notified by probate court when the hearing will be, but you don't get notification of the deferral conference. So the probate court doesn't set the deferral conference. It would be agreed upon by the hospital and then the respondent's attorney. So again, if you have any trouble, I would suggest maybe starting with the probate court and then, letting the judge know there that deferral conferences are not being held. And perhaps that probate judge would be willing to send out communication reminding everyone of the statute. So just for everybody's knowledge, the order and report on alternative mental health treatment is actually a recommendation for that individual who is currently hospitalized prior to the hearing. So it provides information regarding the respondent's status in the hospital and what will be needed if they are released on an outpatient treatment component of the order. So there's just some basic information that is completed. It's just letting everybody know what kind of order is being requested. It's also should be, it should also be completed by the CMH. So whoever the CMH provider is the person or persons who should be completing the order and report. And it's basically providing some history. Sometimes that's not available if they're a new member or if they haven't been engaged in treatment. Can we scroll down a little bit? So the actual report here, the report on evaluation of hospital treatment and or alternative programs would be completed again by the CMH if possible, or if they have an independent medical profession or mental health professional, if they have a private psychiatrist or they have private insurance. I've not seen that usually be the case. So more oftentimes than not, it's the community mental health provider. And what they're doing here is listing information that they have assessed the individual and they are recommending the following alternatives to hospitalization. If we can keep scrolling, you see they have information about substance abuse treatment, community mental health treatment and programs. It has their information as far as supports, if they're in an AFC home or a nursing home, and what the recommendation is once they are released into the community. And if you see there at number 5, you recommend a course of treatment such as hospitalization, combined treatment, or AOT only. Normally, this would follow the track of the petition. So whatever the petition was requesting that was originally submitted to the court, that information would be reflected in number 5. Number 6 allows the person who is doing the assessment to put down any additional information. So sort of like the information that will be listed on the clinical cert. If the person has a durable power of attorney or advanced directives, that information would be reflected in number 7. And then number 8 is it follows the actual mental health order that will be granted. Does the person who is providing the assessment believe that the hospital that they're currently inpatient or that they're currently hospitalized in can actually provide the treatment that they need, yes or no? And then who the recommended agency, CMH agency, or if they have a private psychiatrist, who will supervise the outpatient treatment. Then number 10, it lists their source of funds to cover their care. So if they have Medicaid or Medicare or private insurance, that information will be reflected on number 10. If there are no funds available, that information should also be reported because that means there's some additional information or some additional coordinating that needs to be done before the person is discharged from the hospital. And that information is reflected in number 11. And then that person will sign and date it. That information should be provided to the court, back to the court, I believe 24 hours before the hearing. So that information should be turned in and submitted to the court so that the court has a chance to review it before the hearing. And just for everybody who is here from Wayne County, we no longer use this form in Wayne County. So this is not something that we frequently use, and it's because of the volume in Wayne County. It's not always possible for us to get this form filled out. But if you have the ability to do so and you're able to, and you know that the person is going to hearing and that the person is going to be released on a combined order or was recommended that the person be released on a combined order, then by all means, I would suggest completing this form and sending it back for additional information for the court. Any questions? No, none of the documents require a notary, Sandy. Okay, I think we can move on to the next form, Olivia. I don't see any more questions.
I'm sorry. I have a question real quick. This is Mike
Okay.
Comp, and I'm driving, so hopefully this is going to work out. I had asked previously, and I'm curious about this form as well. If you are recommending substance use treatment on the form, it would seem to run counter to the requirements of 42 CFR Part 2. And if you're a Part 2 provider and you're providing information about a person's substance use or the treatment that's recommended for the substance abuse, it would seem to run counter to that confidentiality rule. And I'm wondering if some point in the future, if we could have somebody come in and talk to us about the interplay between the mental health code, HIPAA, and 42 CFR.
That might be a good question for Olivia, but yes, Sojourner just put a good point into the chat that mental illness is not primary, or mental illness is primary, not SUD. Olivia, can you scroll down a little bit?
Yes.
Okay.
Sorry,
Oh, we're on the next form now. Yeah.
Yeah, no, my bad.
Yep, if you could scroll up a little bit. So here for substance abuse treatment, really what you're doing is just listing what agency you would be recommending for that individual. So it's not asking for detailed information that would violate HIPAA. I've not seen anything in my experience with the court when we did use the form that violated HIPAA in any way. It's kind of along the lines of the order. When you get the actual orders, SUD treatment can be ordered, but there's no specifics that the court is really asking for as far as what their substance use disorder is, or what they need as far as treatment. Is just recommending an agency that can actually provide that service.
So I think a strict reading of 42 CFR might suggest that you couldn't list that information on a public document without consent from the consumer. And so I'm just wondering if at some point, I mean, whenever we talk about this, we always talk about this relative to the mental health code and sometimes relative to HIPAA. But I'm wondering if somebody could come in at some point and talk to us about how does 42 CFR influence this process?
Most definitely. Yeah. Michael, this is Olivia Cessna. This has definitely come up several times, and we acknowledge it. And when looking at this intersection, we have thought that it might be a good idea to, because of how much demystification needs around this particular subject matter, that it would be beneficial to have like a separate kind of event or lunch and learn where we can invite others beyond the CMH role as well. So yes, to short answer, yes, we have that on our radar, and whether we address it in this space or we facilitate a different space and have a wider audience, this is on our radar. And I appreciate you bringing it up, and we are aware and have something in the works. So thank you, Michael.
And
Great.
then also
Thank you.
remember that when this form is sent out, you have usually 2 clinical certs that go after it. And so it's not like a psychiatrist or a psychologist or someone hasn't examined the member. This is primarily done for if it's an out of county petition inserts, so that you need for the CMH or PIHP need to complete this in terms of what they think. This is your evaluation for the treatment team who will be treating that member at that given time, if that makes sense.
I will add, in Genesee County, we do these on every single submitted petition. But to kind of how we fill them out for like this section, a lot of our petitions are asking for combined. And so we're saying at this, like for 2A, B, C, and D, a lot of times we're writing not appropriate at this time. Individual requires more intensive services at a hospital level. So we're not recommending anything for ABC because that individual needs to be in the hospital. And then if you scroll down to, for 3, a lot of that is, not appropriate at this time. And, you're checking number 5, I'm requesting a course of treatment at the hospital for, 60 days followed by AOT treatment as follows. And then you're listing, case management plan, case management services, blah, 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 whatever that they need. So many times for us, unless it's an AOT only petition, we're not putting any substance abuse things on there because the main thing that we're recommending is the hospitalization. And then for our AOT only, if we are saying that we're asking, I recommend a course of treatment of AOT only, we're only identifying the services that are available in the community, not the specific needs of that individual. So, we're listing AA meetings, NA meetings, Flint Odyssey House, stuff like that, for the available treatment programs that are available in the community for that individual. And I don't think this is, Kristina, you can correct me if I'm wrong, this is not a public forum, correct?
That's absolutely correct.
But this is great. This is great discussion around this form. Is there any other final thoughts or?
If ordered by the court, would then be placed on an AOT, and that is public record. And so I think the question is, it seems on one hand, just providing general information about a resource that's available in your community is not confidential. However, I think the concern is if it's related to substance abuse treatment, are you inadvertently acknowledging that this person likely has a substance abuse treatment need? And is that breaking the rules for the 42 CFR?
Yes, that's exactly it. That's exactly the question.
I understand that. I was just saying
I understand.
that probably 95% of the time, you're not even writing that in this form, is what I was trying to get at.
And the actual order would have those AOT services, so if SUD treatment was recommended, then that would be on the actual order, which is public. So I understand, what the questions are, but that is a non-public record or form, as Jenny stated, so it's not shared outside of the court.
Sure. And I just want to restate that it does seem to come up, quite often, us needing clarification around this. And as facilitators of this space, like, we hear that is needed, and we'll definitely bump this up in our queue of things that, we are going to address, because this seems like pretty reoccurring. So yeah, we hear you. And on that note, let's go ahead and move on to PCN 230. I'll kick it back over to you, Kristina.
Now, there should be a lot of questions about this form. This is the most dreaded form, I think. So I'll be happy to answer any questions first, and then kind of go through what the intention of this form is, but also to see if anybody has any suggestions about this form, because I know that we get a lot of questions at the court.
One suggestion is that it's 2 separate forms.
Agreed.
Or it's at least very clear what you're asking for and what you're saying, because it's not. And one of the problems are why do inpatient institutions ask for this when it's not necessary?
Mhm.
Mm.
Agreed. Agreed with all those suggestions. Any other questions or suggestions before we get started? Okay, so again, this is the most hated form. It is the PCM 230, and it's the notification of noncompliance, but it also has the request for a modified order combined on this form. The purpose of this form is to alert the court of noncompliance with the originally granted order, or to request a modification to the order because it is not sufficient to meet the needs of the person who is hospitalized. So you can ask for changes to the actual order using this form, but it is a little bit difficult. So I will go ahead and try to walk you through it the best that I can, knowing that the form is flawed. So just putting that out there, and that it can be difficult to fill out, especially from the provider side. So of course, the first thing that you would do is request the modified order if you're doing so. If not, you're just notifying the court of noncompliance and you don't need to check that box up at the top. For number one, you would enter your name, of course, and then you would specify who you are. So first, the agency, that's self-explanatory, that's the CMH. The mental health professional, that would be used for a provider. A private provider. The individual also has the option to petition the court and ask for a modification to their order if they wish. Other would be state your interest in relationship. I've not really seen anybody else petition on behalf of the respondent, but they can. For number two, the individual who is the subject of this notification was ordered to undergo a program of assisted outpatient treatment or combined hospitalization and assisted outpatient treatment. So number two is specifically for individuals who had a combined order and you're asking for something different. So the options that you have to ask for or to state would be that the AOT portion of that order is not sufficient. That's letter A. B, to notify the court that the individual is not complying with the combined treatment order. Or C, that this is for the individual who is actually on the order. They can indicate that they believe that the outpatient, the assisted outpatient portion of the order is not appropriate. So again, this is to notify the court of something with the combined treatment order. And most of the orders that come out of the Wayne County Probate Court are combined. So this would be the section that you would concentrate on completing. Or if the person that was ordered to some course of treatment is requesting some action, they would select box C. For box 3, if you believe the individual needs to be returned to the hospital on the combined order, then that box will be checked. You would specify how many days they were hospitalized on the original order, and it's basically asking the court to have them hospitalized again for noncompliance. Number 4, this is where you put the reasons why you're asking for this modification or the reason why you're notifying the court of noncompliance. So it's similar to the petition in that you're putting your personal observations or what a witness has informed you of. So that would be for number 4 and A or B. At the very least, 4A needs to be completed. Of course, B is optional depending on the situation. Number 5 would be asking, or informing the court that based on your observations, the treating psychiatrist has ordered the individual to return to the hospital. And you would check that box if that's the case. Number 6 is if you have checked the box up at the top to request a modification, you would request the court to modify its last order of AOT or combined treatment. So you would select which order the person is on currently, and then you would specify what you're asking. So you would ask that another assisted outpatient treatment program be ordered meaning, if you want to change services on the AOT, because the current services were not serving the individual, then you would check box A. If you're asking that the individual be rehospitalized on the combined order, then you would check box B. And then box C would be if this person is in the community, so they're already serving or on their outpatient treatment portion of the order, and they need to go back to the hospital due to noncompliance, then you would check box C. And then, of course, for everything else, it's pretty self-explanatory. In the bottom, you need to sign and date it and put all of your information and submit it to the court. Now, here in Wayne County, we require that the form be also sent to DWIN as the PIHP for Wayne County so that they're aware. But in your county, at the very least, it needs to be returned to the court. And Nina had a good question for considering days hospitalized. Is that days period per the last episode or just the order or just after the order was activated? So it would be just after the order had been granted. So it wouldn't, any of the hospital days prior to the order being granted would not be considered, but any days that apply after the order was granted would be completed for that box number 3. You're welcome. And then I know that Sojourner always recommends and requires for DWIN that the clinical recommendation be added to this form. Of course, there's not a lot of space, but it's really a good practice to kind of add that information so that the court knows what's happening and what should be done or what will be done. A lot of times when this notice is being sent to the court is to notify the court of noncompliance, and you as a CMH provider may not know where the individual is. So you cannot request to modify the order if you don't know where the individual is. So that's a good thing to remember. You can notify the court of noncompliance, but we wouldn't be able to change anything without the individual being served notice and a hearing being scheduled.
I have a question. You get a couple people said that this form is unnecessary, and in our county we use it a lot. So I'm wondering why individuals feel like it's unnecessary.
I would be curious to hear about that. I don't think it's more so unnecessary as it's just confusing. That's my personal opinion, but I would love to hear other opinions about it. I think that the court should know because it is a civil commitment order. So the court should know when someone is not compliant with the order that the court has granted. And it serves to help in different ways because, for instance, if we get this form that somebody has been non-compliant, 9 times out of 10, we'll end up getting either a transport order request at some point for this individual, or we would get a petition because this person has been hospitalized again. So the court can then provide that information to the hospital. You know, they're already on an order. A notice of non-compliance has been filed. You may want to reach out to the provider who filed it so that you can coordinate care. So I think it's a useful form. I just think that it's confusing. Sojourner, would you like to answer the question about where you would like to see the clinical recommendations listed on an attached? Danica, you're asking, should it be on an attached form? Normally for us, it needs to be because there's no room on that form. But I'll let Sojourner answer about Wayne County if it differs from what I said.
Okay, thank you. No, it's the little space that's there, and primarily what it is that we'll get notifications of non-compliant that the member isn't coming in. We can't find them. We sent the letters out. And for one thing, for certain, we know where this member will likely end up, which is back inpatient. And so if the member comes back and we find out what is that the internal clinical team from the outpatient CMH provider is requesting, is it a warm handoff? Is it, to be consulted for coordination of care? The court doesn't know anything clinical unless you tell them. And so it's kind of like help us, help them, help you to help the member. And so kind of tell us what you're looking for, their patterns, etc., so that we can try to get them engaged with treatment, stay engaged in treatment, and if we need to modify or go for a second or continuing order, what's going to happen different than when they came the first time, if that makes sense.
Would you like to see that on an additional form or just in that little space? I mean,
Within that
because
little
it may not
space,
be. Okay.
we don't need the whole clinical history of the member, just a snippet to be able to assist, because hopefully if the member does go back inpatient, then that coordination care will take place between the inpatient facility and the CMH provider so they can get that going.
Thank you.
Any responses to Jenny's question about it being unnecessary? I'm curious. It's a safe space. Okay. Maybe not unnecessary, Jenny, maybe just confusing.
I mean,
Okay, maybe I misunderstood.
Maybe. I don't know.
we're still
I do
talking
think it's
about the
confusing.
non-compliance, change the order form.
Mm-hmm.
I mean, I think there's a place for it, but I think it's just overburdened from some of this the partners involved in the process. And so it gets diluted and unintentional. It starts to become an irritation instead of a purposeful avenue. And so, yeah, there's definitely work to be done around it to make it more effective. I don't necessarily have all the answers, but I have plenty of experiences with the questions. And it's really frustrating for team members, you know, when you're trying to create content experts within your organization. The other institutions create problems because you're educating your team on the legalities and the steps that are laid out by the court. And these other partners are changing the rules that prevent care if you don't follow their changes and rules, but they're really not legally necessary.
Understood. And I see that oh, I'm sorry.
And say for us, we don't turn them in on every single like small incident of notifying of non-compliance. Like I turn them in, you know, whenever we're needing to hospitalize somebody, but then or do a request to modify the order. And then also if individual has basically if an individual has been missing for over 90 days and we're going to be closing the case, but just keeping them open to my AOT monitors to follow the order and try to find them. I send that, but I don't request anything. I just kind of put like, hey, so-and-so is not compliant. You know, we've done this outreach and due diligence, and then I don't fill out anything for the, you know, what I'm requesting the court to do. And I started doing that after, so we weren't doing it before, but I started doing that after we have an attorney that likes to argue every single thing that we've done. And because we didn't have that into the court's record about the non-compliance, he was arguing things saying that, you know, we didn't do X, Y, or Z, when really we did, but we didn't notify the court that we did X, Y, or Z.
Thanks, Jenny. That was a good point. And Jennifer said that she has also done that. She notifies the court, but not requesting anything. And we understand that, but we just, you know, make it a part of the court record. Like I said, normally those people show back up in some way. And here in Wayne County, we're working to ensure coordination of care. So if we can even link somebody back to let them know, you know, hey, this person's provider notified us. Did you make sure that they know that this person has been hospitalized again? Or if the police are requesting a transport or someone else is requesting a transport, we can coordinate care. And that's the goal of our court anyway, is to do that, but realizing that that form has its flaws.
Does anybody have the experience that maybe it's just us because we have 6 different probate courts that we serve, each judge has a different opinion of when they want to be notified, right?
We had that problem in Wayne County till we only had one judge now listening to all those cases. So prior, yes. So I definitely understand that. Each judge is different.
Mhm. Well, this has been a great discussion. Are there any other last minute thoughts before we address some of the forms that y'all identified in the poll?
So I don't know where it's gonna fit. I don't know if we're there or, but I have a couple things. One is if we'll get, I don't know that it's a specific form, but it's a step in the process, which is to get treatment plans back to the court. So I'm interested in knowing what people are utilizing for that. If you're literally giving them your electronic health record treatment plan or some other summary of it. And what's the accountability process within your agency, making sure that that's happening? That's one of my questions. The other question I have is anybody successfully getting combination orders without a person first going inpatient?
Good question. I've never seen I'll start with the easier one. I sent Olivia the name of the form that we use. If you want to Google it, Olivia, you should be able to find it to notify Wayne County that the IPOS has been updated. But for the combined treatment order, I've never seen one initiated without that person being in an inpatient setting. But I would be curious if anybody else has.
Well, we've done it at least once here. That's why I was curious if anybody else has done that, because it only requires 2 certs in order to make it happen. Just curious if anybody else was doing that or found a reason for it.
We've done it here at West Michigan CMH a couple of times, but not too often.
That's good to know. It'll take the transport orders out of the loop. So just get you right in. That's a good way to do things. Did you find it, Olivia? If not, I can share my screen. Oh,
No,
you got it.
I just found it.
Okay. So this is the form that the Wayne County Probate Court uses for both the CMH and the hospital to provide the court notice that the case management or treatment plan has been updated and filed. So the first section is for the hospital actually to notify the court that they have provided the discharge plan or the case management plan or whatever your judge calls it to the clinically responsible service provider and the CMH. So normally in Wayne County, because DWIN does not provide direct services, we have that form that says the CMH agency name, which is normally DWIN unless there's an out-county provision there. And then the clinically responsible service provider, which would be the actual agency. And they would fill out that top form or that top part of the form, and then they would sign and date it with their title. And then once the person is seen by the clinically responsible service provider and their IPOS is updated within 30 days, then they will send that form back by completing the bottom portion of this form, which states that they are a representative of the CMH agency. So whatever clinically responsible service provider is providing the services and supervising the AOT, they would put that the name of that agency there and then sign and date it with their title and send it back to the court. So we don't actually get any protected information or anything like that. We just want to know that it was done.
Thank you.
You're welcome.
Is this document on somewhere where we can have it?
If you want to give your information to Olivia, I'll get you an editable copy of it. It is located on the Wayne County Probate Court's website, but it's in a PDF version.
Go ahead and pass that along for sure.
Thanks, Olivia. And I see that a lot of people are saying that they don't actually provide the service, the IPOS to the court, just something letting them know. For Sandy, you can fax it, email it, that form to us. So the same place that you send the mental health petitions is where you would send that form for the Wayne County Probate Court anyway, or fax. Megan is saying we have a letter that is sent showing what authorizations are current for the individual. We do not include any SUD off. Good, that's a good way to handle that. In the letter, we address what services the court order that have not been authorized. That's awesome.
Hey, this is Mike Thompson. Can you talk a little bit about the process that you use? It says on there that the treatment plan was prepared by the psychiatrist. What does that look like?
For the form that we use in Wayne County?
Yes.
So the hospital is supposed to prepare a treatment plan prior to the individual leaving the hospital. And that information would contain basically their discharge planning. So what would happen in the community if they're being released on a combined treatment order. So the court is not privy to that. We've never seen it. We just require that form is sent. So maybe somebody from the CMH side can provide more information, but that's not something that I will actually see.
And so it's basically the discharge summary from the inpatient setting. So if they went inpatient for a period of days, the psychiatrist at the hospital testified in court to have the member placed on the order. Statutorily, it just states that, hey, there is a discharge plan developed. We are passing it on to whoever the CMH provider is, so that they can continue and pick it up and do that coordination of care. The second one is for if they, once they're discharged, they're placed on an order, or if they went back to the hospital or something like that, and you need to amend the IPOS to reflect that the member is on a current order. So the court never gets the plan. It's just that, you are acknowledging that you recognize that the member is on one. And then your treatment modalities are based upon what those clinical recommendations were at that time.
Thank you, Sojourner.
You're welcome. So regarding the poll that I had launched at the beginning of this meeting, 5 people each had identified PCM 209A, which is order for examination and transport, as well as PCM 217A, which is order regarding requests to modify order for assisted outpatient treatment or combined hospitalization. Yeah, we had 5 people each identify those as wanting to be addressed. So if I could just ask, like, those of you who did mark those, I just want to open the floor and ask why you marked those, and if there's anything particular you'd like to talk about with either of those forms. I'll go ahead and share it.
Okay, for me, down in the it is ordered part, and I don't know that it's a problem with the form so much as it is the wording in the mental health code. That when you take a person in, have them picked up to be taken into the ER for an exam, you either have them examined by a psychiatrist or a psychiatrist and a physician or licensed psychologist. And that places an undue burden on a lot of the smaller ERs, and actually keeps the person in the ER longer to try and track down a psychiatrist to give an evaluation along with the physician.
It's not even possible for me to provide that, and my judges understand that.
It is the code, so I know that there's a lot of work being done to change that part of the code to allow for other mental health professionals an opportunity to conduct those assessments and evaluations and complete those certs. But I hear a lot around the around the state where different judges are doing different things. Like Carol said, I think just is dependent upon, your situation and what's available in your county. And if your judge is flexible about it. I know that a lot of counties have had to make some changes, if you will, to how they do things around the certs.
Well, this places a burden specifically on the hospital, and I've seen some ER doctors not release the person, especially over a weekend, when it has been ordered by the court for a psychiatrist to evaluate the person.
Well, the court is following the law, so that's just what the law states. So again, I don't want to say that the judges can order something different, but the judges can make a determination as to what is necessary. Here we have a couple of crisis centers in Wayne County. So we always try to make sure that individuals are going to crisis centers as much as possible because of the issue with the EDs. But I know that's not possible everywhere else, but I think it's worth a discussion with the probate court to the extent that you can, if you can.
And utilizing telehealth if possible, to be able to get that other evaluation. Because of COVID, we are doing a whole lot of electronic stuff that we didn't do in the past. And so you can have someone do a telehealth, send them the form, do the electronic signature, etc. But just make sure if they get called to court, they can testify.
If I can, for how we've done this with Judge Barkey, we'll bring the person to the ED. We don't have psychiatrists at our ED, but they are assessed by that doctor. If the doctor feels that they would meet criteria for inpatient, then they send them upstairs to that IPU. And as soon as they're upstairs, they are assessed by the psychiatrist. If the psychiatrist disagrees, they are immediately discharged from the hospital. And if the psychiatrist does agree, then, we have kind of basically our way is that, you're just going through a gate of the ED with, that MD saying, yes, sir. Yes, this does seem like the least restrictive thing for you to go to the hospital. I'm going to send you up to the psychiatrist, versus, no, you don't seem to need hospitalization. I'm going to let you go out the door. And that's just because we also have the limited ability to have the psychiatrists too. So just thinking of the least restrictive intervention for those individuals, that's just kind of how we've been able to go about it with our limited resource for psychiatrists.
I was a crisis screener in an ER of a level 2 crisis ER throughout the pandemic that had a behavioral health unit. Doing it that way, if we would have followed the law strictly as it was, people would be waiting weeks and weeks and weeks to go up for that one evaluation for a psychiatrist to set them free. It takes an awful lot of resources and effort just to get them to the door of the psych unit.
It does. And, like Kristina said, that there's some pending changes for the law to allow for more people because of that exact reason. But I just wanted to share what we were doing right now to follow the law to the best of our abilities, given what resources we have right now.
Thank you so much. We're a little bit past time, but thank you so much, Kristina, for being here and answering all these really insightful questions about the forms. I'm feeling like there has been a lot brought up here today that we should follow up on in terms of creating an additional dialogue for what was brought up here today. Also, thank you, Jenny and Sojo, for giving your expertise on these issues as well. And thank you so much, everybody, for coming. I will be sending a follow-up email communicating the forms that were brought up today. And please reach out to me for any lingering questions that you want answered. And of course, always willing to accept feedback for these spaces. These are spaces created for you. So if there's things that we can do to better curate this to you and your experience, then please let us know. So yeah, thank you so much, everybody, and have a great weekend.
Thank you.
Thank you. Thank you.